One of the questions that Simon asked me to address is whether there are any cautionary tales about the use of social media. Exhibit A in that regard is the story of Christine Ann Pishak, a former public defender in Illinois. Attorney Pishak faced disciplinary charges from the Illinois Attorney Registration and Disciplinary Commission based on her blog, where she was writing about her cases and her clients. She believed, I guess, and maintained that she was blogging about her cases in a way that was designed to maintain the confidentiality of her clients, to mask the details of her clients and cases. But she was blogging with sufficient detail that those who were familiar with her clients could identify them. And in some cases, as I understand it, she was using their prison identification numbers, which would mean that at least those in the know could identify her clients. And she was blogging somewhat embarrassing and even perhaps incriminating details about some of her cases. In one blog post that was cited by the Illinois Disciplinary Commission, she described how she had just left a sentencing hearing with her client, at which the client had maintained and told the judge and told her that he did not use drugs. As they were leaving the hearing, I guess the client turned to her and said, "Should I go back and tell the judge that I'm using methadone?" Her reaction, as she described it in her own blog post, was as follows: "Huh? You want to go back and tell the judge that you lied to him? You lied to the pre-sentence investigators, you lied to me, and you expect what to happen if you do this? I'll tell you what would happen. The sentence just pronounced would be immediately vacated and you'd go to prison. That's what would happen." So here we have her in her blog describing her advising her client not to be truthful with the judge, and implicating perhaps both her client and herself in one fell swoop. Ms. Pishak was ultimately suspended from the practice of law for 60 days. And the moral of the story, I guess, is not to blog about your own clients and cases. I always advise lawyers not to do that. You can blog about your cases, of course, if they've been publicly reported, if you just won an appellate case, if there are details about your cases that have been publicly reported. But you have to be really careful about doing that. And there is so much more to blog about and so much more to write about. You can write about trends in the law. You can write about other people's cases. But you really want to avoid writing about your own cases and clients. That's my advice anyway.